Imagine you are a parent in Indiana in 1910. Your child has seizures, or falls behind in school, or your family is too poor to manage alone. A doctor sits across from you and tells you the state has a school, a real school, with a campus, a superintendent, trained staff, and the full backing of the state of Indiana. He says it is the humane option. He says the alternative is worse. You sign the paperwork. You go home. What you do not know, what the paperwork does not say, is that inside that building, officials are already deciding whether your child will ever be allowed to have children of their own. And that the system you just handed your child to will one day be studied, copied, and scaled by a foreign government into one of the largest programs of human destruction in recorded history. This was not a rumor. This was not a local legend. This was state policy, documented in annual reports, defended before national medical organizations, and built into the legal framework of the United States. The institution was called the Indiana School for Feeble-Minded Youth. The address was East State Street, Fort Wayne, Indiana. And what happened inside it did not stay in Indiana. On July 8, 1890, a train pulled into Fort Wayne carrying more than 300 children from a temporary facility in Richmond. They were the first residents of a new state institution authorized by the Indiana General Assembly in February 1887 and designed to house, train, and care for children the state had classified as feeble-minded. The campus would grow over the following decades into a substantial operation: brick dormitories, farmland, workshops, a self-sustaining institutional economy. The state presented it in annual reports to the governor as a model of progressive care. The language used in official documents was consistent: treatment, training, protection, education, public health. Indiana was not trying to look like a place of harm. It was trying to look like a modern, compassionate state. The people sent to Fort Wayne were not sent there because they were violent. They were sent because their families were poor, because a doctor filled out a form, because a county official decided their behavior made them a burden. The category of feeble-minded was never a precise medical diagnosis. It was a catch-all wide enough to include people with genuine intellectual disabilities, people with epilepsy, people who were simply impoverished, immigrants whose English was limited, children who had failed a test designed for a different kind of child. Once classified, they had almost no legal standing to challenge the designation. Once inside, they had almost no way to leave. Residents were divided into two classes. The custodial class, those deemed too impaired to be useful, were housed and managed. The industrial class learned to farm, to make bricks, to do laundry, to sew, to can vegetables. The institution fed itself largely through their labor. That labor was not compensated. The state called it training. The residents called it, if they were asked, which they rarely were, their daily life. The first real crack in the official version came not from a journalist or a lawyer. It came from the state itself. On March 9, 1907, Indiana signed into law the first compulsory eugenic sterilization statute in the history of the world. The law made sterilization mandatory for criminals, idiots, rapists, and imbeciles in state custody, and it specifically named institutions like Fort Wayne as the places where this would happen. A board of 2 surgeons would convene. They would assess the patient. If they determined there was no probability of mental improvement, sterilization could proceed. The surgeon would be paid no more than $3. Then something unexpected happened. A sitting governor, Thomas Marshall, halted enforcement in 1909. He had questions about the law's constitutionality. In 1921, the Indiana Supreme Court answered those questions definitively. The law violated due process. It was struck down. For a moment, it looked like the machine had broken. It had not broken. The people who built it went back to work. They needed a law that would survive constitutional challenge. In 1927, the United States Supreme Court handed down Buck versus Bell, upholding Virginia's compulsory sterilization statute in an opinion by Justice Oliver Wendell Holmes that contained 8 words that would travel far beyond the courtroom. 3 generations of imbeciles are enough. Indiana read the decision and passed a new sterilization law the same year. This one had procedural guardrails. Patients could theoretically appeal. It was harder to challenge, and it sent more people through Fort Wayne than any law before it. By 1932, the institution had formalized what was already happening in practice. Sterilization became a documented condition of release. If you were a resident of Fort Wayne State School and you wanted to go home, the board could require that you first submit to an operation that would make it impossible to have children. The Depression had made institutions like Fort Wayne financially stressed. Discharging residents reduced costs. Sterilizing them first made the discharge feel safer to the officials authorizing it. The logic was economic as much as ideological, and the records show it. Between the fiscal years 1927 and 1936 alone, Fort Wayne's own annual reports document 308 sterilization operations, from the passage of the 1931 law through May 1934. 141 people were processed, 51 boys between the ages of 6 and 15, 37 girls between the ages of 6 and 15, children. And the people running the program were not hiding. In 1934, Dr. L. Potter Harshman, the state psychiatrist at Fort Wayne, appeared before the American Association on Mental Deficiency in New York City. He presented the numbers. He called sterilization a convenient arrangement. He called it progressive. He said it allowed more defectives to be released into the community. He said this in public before a national professional audience, and the audience did not object. The warning the records give us is not that this was a secret. The warning is that it was public, professional, and praised. The state toured the facility in 1944 and documented 1,918 residents packed into a campus built for 1,500. Officials used the words extreme overcrowding and fire hazard in their own reports. The conditions were acknowledged. The policy did not change. By 1932, somewhere between 1,500 and 1,800 people would eventually be sterilized at Fort Wayne, accounting for approximately 75% of every eugenics sterilization performed in Indiana. Indiana was by that point not just a state with a troubling institution. Indiana was the origin point. The first law, the first bodies, the first national template, and someone else had noticed. The man who noticed was named Harry Laughlin. Laughlin ran the eugenics record office at Cold Spring Harbor Laboratory in New York, and by 1922 he had done something with Indiana's experiment that the Indiana legislature had not managed to do themselves. He turned it into a product. He took the logic of the 1907 law, stripped out its constitutional weaknesses, and published a model sterilization law designed to survive any court challenge. It was distributed to state legislatures across the country. More than 30 states eventually adopted versions of it. Laughlin corresponded regularly with eugenicists in Germany. He knew what they were building. He wrote in his own eugenics journal with evident satisfaction that the Nazis had based their law on his American model. In 1933, one of the first laws passed by Adolf Hitler's new government was the law for the prevention of offspring with hereditary diseases. Historians and legal scholars who have studied both documents, including Stefan Kuhl in The Nazi Connection and Alexandra Minna-Stern at the University of Michigan, have documented that the 1933 law was modeled directly on laws in Indiana and California. The Nazis did not invent the bureaucratic infrastructure for mass sterilization. They inherited it, they translated it, and then they scaled it in ways that the Americans who built the original model had not anticipated or had not admitted to themselves they were enabling. In the first full year of operation, the Nazi sterilization program processed approximately 80,000 people. Over its full run, more than 350,000 individuals were sterilized without consent under that law. Germany rewarded Laughlin in 1936 with an honorary doctorate from the University of Heidelberg, awarded in the university's own language, for his services on behalf of the science of racial cleansing. Laughlin accepted. The degree came 1 year after Heidelberg had purged its Jewish faculty. He did not return it. He did not publicly object. He framed it in correspondence as a high honor. The sterilization program was not the endpoint. It was the threshold. The physicians and administrators who built the sterilization bureaucracy, the boards, the hearings, the forms, the procedures, were the same people who, beginning in 1939, staffed the operation that Nazi officials called Action T4. This was the systematic murder of disabled people, patients in institutions across Germany and occupied Europe killed by starvation, lethal injection, and eventually gas. The estimates run between 250,000 and 300,000 people killed. The techniques developed for T4, including the use of sealed chambers and carbon monoxide, were later transferred directly to the death camps. The personnel who operated them followed. The road from the sterilization board at Fort Wayne to the gas chambers at Auschwitz is not a rhetorical device. It is a documented bureaucratic progression built on the same premise, that certain lives were not worth sustaining and that the state had the authority to act on that conclusion. This was confirmed in the most explicit way imaginable at the Nuremberg doctors' trial after the war. Karl Brandt was Hitler's personal physician and the administrator of the T4 program. His defense attorney introduced documents into evidence that cited Harry Laughlin's 1914 proposal for the sterilization of 15 million Americans. He quoted a German translation of the Buck versus Bell opinion. Other Nazi defendants cited it as well. Holmes's phrase, "3 generations of imbeciles are enough," appeared in a defense exhibit titled Race Protection Laws of Other Countries. The argument was direct. The Americans had done this first. The Americans had done this in law. The Americans had called it progress. The American government did not respond to that argument by overturning Buck versus Bell. It has never overturned Buck versus Bell. The decision remains binding precedent in the United States today. Back in Indiana, the sterilization law continued operating for nearly 3 more decades after Nuremberg. It was not repealed until 1974, when Governor Otis Bowen signed the repeal into law, and even then, the logic it had licensed did not disappear cleanly. In July 1971, 3 years before the law was finally struck from the books, a woman named Ora McFarlane walked into the DeKalb County Circuit Court in Indiana with a petition. She wanted her 15-year-old daughter sterilized. She told the judge her daughter was somewhat retarded and was associating with older men. The judge, Harold Stump, signed the order the same day she filed it. No hearing was held. No guardian was appointed. The girl, Linda K. Spittler, was never told what was happening to her. She was brought to the hospital and told she was having her appendix removed. 2 years later, Linda married. She and her husband tried to have children. They could not. In 1975, she learned the truth. She sued Judge Stump, her mother, the doctors, the hospital. The case went to the U.S. Supreme Court. In 1978, in Stump versus Sparkman, the court ruled 5-3 that Judge Stump was protected by absolute judicial immunity. He had acted within his jurisdiction. The fact that no statute gave him the authority to order this sterilization, the fact that he held no hearing, the fact that the girl was never told, none of it was enough to pierce the immunity that the law extended to judges. Linda Sparkman received nothing. Judge Stump faced no consequence. The Seventh Circuit, in its earlier ruling that the U.S. Supreme Court overturned, had been more direct. Judge Luther Swigert wrote that a juvenile had been ordered sterilized without the slightest steps taken to protect her rights, that she was not even told what was happening to her. The U.S. Supreme Court found this insufficient grounds to hold the judge accountable. The Fort Wayne State Developmental Center, the institution, had been renamed and relocated to a new campus in 1954. Closed in April 2007. Its last resident left on April 18th. The closure had been announced in 2005 and took 18 months to complete. The campus on East State Street, where the original school stood, had already been demolished in 1982 and turned into a public park. A stone archway from the original building was preserved. The institution cemetery, where residents who died inside the facility were buried, holds unmarked graves. On April 12, 2007, Indiana marked the centennial of the 1907 law with a historical marker at 140 North Senate Avenue in Indianapolis, outside the Indiana State Library. Health Commissioner Dr. Judy Monroe unveiled it alongside a woman named Jamie Renee Coleman. Jamie Renee Coleman is the name Linda Sparkman now uses. She changed it after the lawsuit. She co-authored a book. She was not sterilized under Indiana's Eugenics statute. Her case was a judicial order with no statutory basis, but she was invited to stand next to the state's apology and pull back the cloth. She did. The marker reads, approximately 2,500 people in state custody were sterilized. It does not name anyone. It names the law, the governors, the dates. The system that ran for 67 years is summarized in a few hundred characters on a bronze plate. Behind her, across the street, sat the Indiana State House, the building where, in 1907, legislators voted to make Indiana the first government on earth to authorize the forced sterilization of its own citizens in custody. The institution is gone, the law is repealed, the apology has been given, and Buck versus Bell is still on the books. The legal precedent that Harry Laughlin built his model on, that Nazi defense lawyers cited at Nuremberg, that the Supreme Court has never directly reversed, it is still valid law in the United States. The graves at Fort Wayne are still unmarked. The people sterilized there are still unnamed on the marker. The photographer took the picture. Linda went home. The marker stayed. What do you call a system that told families it was a school, told residents it was care, told the public it was progress, and then built the legal foundation that a genocidal government imported, used, and cited in its own defense at trial? And what does it mean that the foundation of that architecture has never been dismantled?